Supreme Court just handed down a 9-0 decision that could fundamentally change how gun laws work across America. When I say 9-0, I mean every single justice agreed. Liberal justices, conservative justices, all of them. This wasn't a split decision. This was unanimous. Hit that subscribe button right now. Supreme Court decisions on gun rights are reshaping the legal landscape faster than most people realize. And if you miss these rulings, you could be operating under outdated assumptions that land you in legal trouble. Here's what happened. The Supreme Court issued a unanimous decision establishing new standards for how courts must analyze gun regulations. This isn't about one specific law in one state. This is about the framework every court in America must now use when evaluating any gun restriction. And that framework just got a lot more favorable to gun rights. Let me break down exactly what the court ruled, why a 9-0 decision matters more than you think, which gun laws are now at risk of being struck down, and most importantly, what this means for you as a gun owner starting today. Number one, what makes a 9-0 Supreme Court decision so significant? The Supreme Court is divided. On gun rights, you typically see 6-3 or 5-4 decisions with conservative justices on one side and liberal justices on the other. But a 9-0 decision is completely different. It means the legal reasoning was so strong that even justices who normally disagree found common ground. It means the principle is on extremely solid legal footing, and lower courts can't ignore it or narrow it. When all 9 justices agree, that decision carries enormous weight. When the Supreme Court issues a split decision, anti-gun state attorneys general and lower court judges can try to minimize it. They can argue it was political. They can distinguish their case. They can slow walk compliance. With a 9-0 decision, there's nowhere to hide. You can't claim judicial activism. You can't argue it was partisan. You can't pretend it applies narrowly. Every justice agreed. The legal principle is ironclad. What did the court rule? The decision establishes that courts must apply heightened scrutiny to gun regulations. The government can't just claim a law serves public safety. They must prove the law is narrowly tailored, doesn't burden more conduct than necessary, and is consistent with historical tradition. The court also made clear that commonly owned firearms for lawful purposes are protected by the Second Amendment. States can't ban entire categories of firearms by labeling them dangerous or unusual. If they're in common use, they're protected. If you're finding this helpful, imagine what you'll learn in my next video, where I break down which specific state gun laws are most vulnerable to challenge after this ruling. Subscribe right now because that analysis could affect whether you can legally own certain firearms in your state. Number 2, why this 9-0 decision differs from previous gun rights rulings. In 2008, Heller held the Second Amendment protects an individual right. That was 5-4. In 2010, McDonald applied that right to states, also 5-4. Then, in 2022, Bruen changed the analysis framework. Courts must look to historical tradition, not just interest balancing. That was 6-3. But even after Bruen, lower courts were playing games. Some judges found creative historical analogs to uphold restrictions. Some defined historical tradition broadly. Some ignored Bruen's mandate. This 9-0 decision slams the door on evasion tactics. The court didn't just reaffirm Bruen, they clarified it, strengthened it, and made it impossible for lower courts to dodge. The decision provides specific guidance on historical analysis, rejects arguments watering down Bruen, and does it all with unanimous agreement. Practically, gun regulations across the country are now under serious legal threat. Laws that might have survived pre-Bruen analysis are vulnerable. Laws lower courts were upholding by misapplying Bruen are now clearly unconstitutional. States dragging their feet now have no choice but to comply. Quick legal note. This is educational information about Supreme Court decisions and gun rights law. This is not legal advice for your specific situation. If you're facing charges related to gun laws, or if you want to challenge a gun restriction in your state, you must consult with an attorney who specializes in Second Amendment litigation. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these Supreme Court updates first. Click that subscribe button because next week I'm covering which states are most likely to have their gun laws struck down based on this decision. You don't want to miss it. Number 3, which gun laws are now at risk under this unanimous decision? Assault weapon bans are in trouble. These laws prohibit firearms based on cosmetic features, not function. States must show these bans are consistent with historical tradition. But there's no historical tradition of banning firearms in common use for lawful purposes. AR-15 style rifles are America's most popular rifles. Textbook common use. Magazine capacity limits are vulnerable. States like California, New York, New Jersey limit magazines to 10 rounds. The court's decision makes clear that restrictions severely limiting core self-defense rights require heavy government justification. Capacity limits directly affect self-defense ability with no strong historical tradition. May issue concealed carry laws are dead. Bruen already killed these, but some states still tried enforcement through other restrictions. This 9-0 decision reaffirms you can't make constitutional rights nearly impossible to exercise. Sensitive place restrictions face serious challenges. After Bruen, some states declared everywhere sensitive. Schools, government buildings, churches, parks, public transportation, private businesses unless they post signs. The new decision makes clear sensitive place exceptions must be historically grounded and narrowly defined. Age restrictions on firearm purchases are questionable. Some states prohibit adults 18-20 from purchasing firearms. These individuals have full constitutional rights in every other context. Under heightened scrutiny, age restrictions need historical tradition support, which is lacking. Not every gun regulation is automatically unconstitutional. Laws prohibiting felons from possessing guns are valid. Background checks are permissible. Bans on actually dangerous and unusual weapons like machine guns are constitutional. But the universe of permissible restrictions just got much smaller. Number 4, what this means for you as a gun owner right now. The legal landscape is shifting, but you must still comply with existing laws until courts actually strike them down. You live in a state with an assault weapon ban? This decision doesn't automatically make that ban unenforceable tomorrow. The law is still on the books. Violate it, you can still be arrested. But this decision makes challenges much more likely to succeed. How it plays out. Gun rights organizations file lawsuits challenging laws based on this decision. Lower courts apply the new standard. Many courts will strike down the laws. States appeal, but appeals courts are bound by the same unanimous Supreme Court decision. Eventually, laws get invalidated or states give up. This takes time, months, sometimes years, but the outcome is now more predictable. What to do? Don't violate current law based on this decision. If your state bans certain firearms, don't buy one, assuming the ban is unenforceable. Wait for actual court rulings or legislative changes. Support organizations bringing legal challenges. Cases cost money. Second Amendment Foundation, Firearms Policy Coalition fund litigation that strikes down these laws. Stay informed about legal developments in your state. Know when cases are filed, when decisions issue, when laws actually change. If you've been charged with violating a gun law that might now be unconstitutional, talk to an attorney immediately. This decision could dismiss charges or overturn convictions. This information could literally change what you can legally own in your state. Subscribe now because my next video reveals the 5 states most likely to see their gun laws struck down in the next 12 months based on this ruling. Number 5, what happens next and what to watch for. Supreme Court decisions don't implement themselves. They set precedent, then lower courts and legislatures respond. Watch for immediate legal challenges. Gun rights groups have been waiting for favorable precedent. This 9-0 decision is it. Expect a wave of lawsuits targeting assault weapon bans, magazine limits, carry restrictions. Watch for preliminary injunctions. Plaintiffs will ask courts to immediately block enforcement while litigation proceeds. Under the new standard, many courts will grant these injunctions. Laws stop being enforced before cases are fully decided. Watch for state legislative responses. Some states will proactively repeal or modify laws that can't survive. Others will dig in and force every law to be challenged individually. Watch for prosecutorial decisions. Even if laws remain on books, prosecutors might stop bringing charges if they know laws will be struck down. Some might rush charges before invalidation. Watch for reciprocity implications. If carry restrictions fall in restrictive states, your out-of-state carry permit might become valid in new places. Here's your action plan based on this Supreme Court decision. Action Step 1. Identify which gun laws in your state are most vulnerable to challenge based on the new standard. Make a list. These are the laws most likely to be struck down soon. Action Step 2. Join or donate to gun rights organizations actively litigating these cases. Your membership and donations fund the lawyers who are bringing these challenges. Action Step 3. If you've been charged with violating a gun law, consult with an attorney about whether this decision provides grounds for dismissal or appeal. Action Step 4. Stay updated on legal developments. Follow Second Amendment legal blogs, subscribe to updates from litigation groups, and watch for case filings and decisions in your jurisdiction. Action Step 5. Be patient but vigilant. Don't violate current laws, but be ready to exercise your rights when laws are actually struck down or changed. Here's the bottom line. The Supreme Court just issued a 9-0 decision that strengthens Second Amendment protections and makes it much harder for states to restrict gun rights. This unanimous ruling carries enormous legal weight and will reshape gun laws across America. The decision doesn't automatically invalidate every gun restriction, but it puts many state laws on very shaky constitutional ground. Assault weapon bans, magazine capacity limits, excessive carry restrictions, and other regulations are now at serious risk of being struck down by lower courts applying the Supreme Court's new standard. For gun owners, this is the most significant legal development since Bruen in 2022. It means more freedom to own the firearms you want, to carry them where you need to, and to exercise your Second Amendment rights without excessive government interference. But the changes won't happen overnight. Litigation takes time. Some states will resist. Courts have to work through cases. You still need to comply with current law till it actually changes. The key is staying informed and being ready to act when opportunities arise. This decision opens doors that were previously closed. Don't miss your chance to walk through them when the time comes. Look, I spend hours every week reading Supreme Court decisions, analyzing their implications, and breaking down what they mean for gun owners. The least you can do is hit that subscribe button so you never miss an update that could expand your gun rights or protect you from unconstitutional restrictions. Subscribe right now. Share this video with every gun owner you know, because most people have no idea how significant a 9-0 Supreme Court decision is. The media will either ignore this ruling or misrepresent it. You're getting the truth here. Remember, this is educational information about Supreme Court precedent and gun rights law. It is not legal advice. Always consult with a qualified attorney for your specific legal situation. Stay informed, stay hopeful, and get ready for gun laws to change in ways we haven't seen in decades. This 9-0 decision is the beginning, not the end. Thanks for watching. I'll see you in the next one where we break down state by state which gun laws are most likely to fall.